months later, they say, oh, we found it. So I know that there is some staff turnover, but we want one person be responsible for the scholarship, and we want to have clear data and records when we need it. And number three is the timely submission of the reports. We're going to be asking, and with the authorization of the committee and the board, we're going to be asking that they submit a report probably in fall. So I have enough time to review the data and put together a report for the board. So, and we have seen, is the first time seems like we're trying to go this path more about evaluation and data-driven decisions, and the schools probably have not been used to. So that is something that we need a collaboration, because they have that data. They know how, if you are thinking like me, you are saying, how do they give this money to the students? I want to know what is the criteria. That is something that we have not captured. That is something that I would like to capture. So there are things that I think we can add, that we want to be able to be informed how they are doing things. Not because we want to control them, is because we want to be able to have that to be a full analysis of the program. Yeah, so those three things, I think that collaboration with the schools will be very helpful for us to be able to continue developing these reports.
Mr. Castillo, did you have a question? Oh. So just to reiterate, great job.
Thank you so much.
Fantastic.
Thank you.
All right, so moving on the agenda. Next, we have the practical nursing education report.
Yes,
Dr. Burks.
I have several things to bring forward to the board today. First is in regard to the site visits. Coahoma Community College, I have attached their site visit report. Their site visit took place October the 17th and 18th of this year. Again, the detailed report is attached, but I'll just give you a summary of the findings. The program findings was Coahoma Community College Practical Nursing Program was compliant on all the standards and criteria, thus not requiring submission of a corrective action plan. Coahoma Community College Practical Nursing Program successfully met all standards and criteria during the recent accreditation visit, achieving this milestone with no recommendation. This accomplishment reflects the program's commitment to excellence in education and adherence to the highest standards in nursing. The therefore recommendation is, it is recommended Coahoma's practical nursing program receive full accreditation with no recommendations. With full accreditation status, the next review of Coahoma Community College practical nursing program will occur in 2032. Jeremy, go to the next one.
We can go one at a time. So with that being said,
I move that we accept the recommendation on Coahoma Community College.
I'll second.
all those in favor say aye.
Aye.
Any opposed? It will move forward. All right, Dr. Burks, you can move forward.
The second one is Itawamba Community College site visit. That visit took place October the 22nd and 23rd. The program finding was Itawamba Community College Practical Nursing Program was compliant with all standards and criteria, thus not requiring a corrective action plan submission. However, there was one recommendation regarding Rule 3.3, faculty and staff. And that recommendation is, it's recommended that Itawamba's Practical Nursing Program receive full accreditation with the following recommendation. In regard to Rule 3.3, faculty and staff, criteria 2, faculty pursue additional professional development that enhances evidence-based practice in the classroom and clinical setting. They did have professional development. However, after reading through their information, it was a recommendation that they receive more specifically to their classroom setting. And with the full accreditation status, the following review of Itawamba's Community College Practical Nursing Program will occur in 2032.
So with that recommendation from Dr. Burks, would anyone like to make a motion?
Move to approve.
Do I have a second?
I have a question. So, so Priscilla, what do they do when there's a recommendation and not a concern to respond that maybe they have done what you've recommended? Or is that
With that recommendation, and the standards, those things They are actually expected to follow through with them. And so each year they'll submit an annual report. And
Okay.
under annual report, they'll make those adjustments or submit that paperwork. with
Got
the
it.
annual report.
Thank you.
And if they don't, what's the repercussions? I mean, if we approve this for their next, yeah, probably this will be 2032. I mean, that's 8 years. What happens?
Well, in the standards, we can actually, that's their next official, but the way the standard is written, we can go out anytime and do a focus assessment with the school.
Any other questions for Dr. Burks? All those in favor, say aye.
Aye.
Any opposed? We'll move forward. Dr. Burks?
And I have two requests from Northeast Mississippi Community College, and I'll do the first request. Their first request is to change the delivery of PNV 1524, which is the IV therapy course, to a hybrid delivery starting spring 2025. The lecture would be online and the lab checkoffs would be face-to-face on campus. Currently, the current standalone PNV 1524 IV therapy class, it is taught as a hybrid throughout the state. And this will provide them with more flexibility in offering the theory as a the recommendation is that Northeast Community College be allowed to offer PNV 1524 as a hybrid course starting spring 2025. In addition, Northeast should be required to submit the following at the end of each semester of PNV 1524. That is the number of students in the course, the number of completers and non-completers for the course, and a readmit plan for those who are non-completers.
I make a motion that we accept the recommendation on the first request from Northeast Mississippi Community College regarding their change in delivery method.
Do I have a second on that?
I'll second.
Any discussion? In favor, say aye. Any
Aye.
opposed? Sorry, who was that? Did somebody oppose? Okay, sorry. It can move forward. Dr. Burks?
Their second request is to offer PNV 1914, which is nursing transition, as a hybrid and during the spring semester in conjunction with PNV 1524 IV therapy and PNV 1682 adult health nursing concepts and clinical. The recommendation is Northeast Community College be denied the opportunity to offer PNV 1524 and PNV 1822 as a hybrid course during the spring semester based on the following concerns. The student transition. These are considered high-risk students. Students transition from the ADN program to the PM program. They're often considered high-risk students, and they have faced academic challenges in their previous attempts. Placing these students in a situation that involved an increased workload of 20 credit hours to further elevate the risk of their academic failure. The second is the student preparedness and their role mastery. Although these students have completed 2 semesters in the ADN program, the proposed shortened pathway may limit their ability to fully master the role of a practical nurse. While having a pathway for students to enter the workforce is important, it is of the utmost importance for the board to uphold the mission of public safety by ensuring individuals who enter the workforce is efficient and effective. Also, there's learning constraints. Taking multiple complex courses in one semester may not allow sufficient time for students to fully absorb and master the material, potentially leading to gaps in knowledge and clinical competency. With the curriculum standards, this would be a deviation from the work framework. The Mississippi PN curriculum framework is designed to ensure a progression from foundational to advanced concepts. Allowing students to bypass this structured progression could undermine the program's learning outcomes. Also, there's an issue with the credit hour limits. The request for students to take 20 credit hours exceeds the maximum allowed, which is 16 credit hours, under the current framework, further straying from established guidelines. Also, will be a disruption of the learning sequence. The PN curriculum, simple to complex design, is critical for ensuring foundational knowledge and is built for tackling advanced material. Permitting students to take courses prematurely could disrupt their learning and compromise their clinical performance. And the last is the academic standards. the perception of reduced standards, allowing struggling students to undertake an excessive workload and a demanding program may be perceived as lowering the academic standards, potentially impacting the integrity and reputation of the practical nursing program.
I make a motion, we approve the denial of the second request.
Do I have a second?
Just for clarification, that's the denial of PNV 1914, correct? Because I think there's a typo in the recommendation.
Being taught, I think it's the timing, right?
Yeah, it's the timing. They want to teach 1914 in the spring.
Okay, so 19, I just, like I said, there's a typo, and so I want to make
So,
sure.
so we're denying the opportunity to offer PMV 1524.
Offer the 1914 as a hybrid,
It should be.
It should be 1914.
it's 1914.
Well, my motion comes with the amendment, to change that to PMV 19.
Okay, with that being said, do I have a second?
I just have, I just have a question. So,
I was
No,
just
no,
one.
so, so the justification, I was reading their justification, not that I disagree at all with what you're recommending. I'm just trying to understand. So it is just these ADN students that are being delayed graduation by 3 months? That's in essence what we're saying.
The way that program is designed, the ADN students, these are students who have been unsuccessful twice in the ADN program.
Right.
They have it where it's set up, they can come into the second semester of the PN program. So their proposal is to allow them to take their transition course, which is the final course that students take, in addition to them taking adult health as well as IV therapy. The way the courses are set up, there's 16 semester hours. So with the addition of that transition, it's going to put them in 20 hours, which is going to conflict with the curriculum, although the curriculum is not under us.
Right.
That maximum is 16, and programs can go up and down an hour. And so they will far exceed what they are allowed to do. with the
Right.
curriculum.
So these students though will take this course theoretically in the summer. And did they take the transition course with anything else? I'm just curious.
No, it's just that transition.
It's just that, so that's the bridge basically to practice for them. Okay, thank you.
Are they trying to model this after the Mississippi Gulf Coast program where they can defer out after being unsuccessful in those first 2 semesters? Is that the thought process behind this, or is it something completely different?
They may have been attempting that, but Mississippi Gulf Coast is completely different. Because the way Mississippi Gulf Coast is designed, all of their students start out as nursing students.
Right.
And then after that second semester, they opt to either continue on the ADN route or the PN route. But the sequence of their courses do not change. They still are in that sequence of simple to complex at
I
that
see.
point.
Okay. So if they all start out as nursing students, it might look a little different, but since they started as ADN students, were unsuccessful,
Correct.
and then we're trying, okay, I understand. Thank you, Dr. Burks.
Any other questions? All those in favor, say aye. Any opposed? It will move forward. And Dr. Burks, that community involvement, did you want to cover any of that right quick or?
Community involvement was the M&A conference in October. We participated in the USM and a student presentation on October 15th. I participated in Northwest Community College Practical Nursing Advisory Meeting. We presented at Singing River Healthcare Academy, the HOSA Convention, Deans and Directors, NCSBN Education Consultant Meeting. And I must say with Singing River Healthcare Academy, Ms. Montgomery and I, we were their guest speakers. And it was an honor to actually see those students and the things that Singing River is doing to have that pipeline of individuals enter healthcare.
And Dr. Burks, to reflect on what you just said about you and Ms. Montgomery, there was feedback after y'all left because I have some friends down there and they just raved about y'all. So good job. Well, thank you, Dr. Burks, for a great report. All right, next we're going to move on to the executive director's report. Dr. Johnson.
It's gonna be short and sweet, because my report has already been given by the Office of Nurse and Workforce and Dr. Burks. So there's not a whole lot. I do want to wish to the Madam President and the Board of Directors and guests, happy holidays. Hopefully you receive your little happy from the staff here. We appreciate you all very, very much. It's just a small token of our appreciation for all you do and your leadership and your support. So, best of, the holiday season to you and your family. As you know, our mission here is to protect the public. I got my blues brother over there on the end. I always, Drew, with his shades on. I keep looking at him, he throws me off. But see, I digress when I saw you. But our mission here is to protect the public. So that's what we strive to do each and every day. And just let me say this. You just saw a snippet of what I enjoy working with every day. I have the greatest staff in the world. And this is just a snippet of what I get to be involved with every day here at the Board of Nursing. So I just want to give my staff a hand because of the great work that they do. Because without them, I am nothing. I can't do half the work that I do without the staff that I have. They do a tremendous job, and I'm lucky to be involved with such an exceptional team of individuals that promote that mission of protecting the public. They come to work every day to do a job, and they do it well. I'm excited that I have somebody that is data-driven. ONW has been talking about telling the story for years. You all know that. Some of you have been on the board. Here's the opportunity to tell the story because the data is being gathered. The dashboard, you'll be able to play with the dashboard on the website. So I think it's very important, you know, what we're striving to do and what we're evolving to do as we move forward in our mission. Very shortly, just the updates, mid-year, make sure it's on your calendar. March 11th through the 13th, 2025, it'll be in Pittsburgh, Pennsylvania. Capital Day, my illustrious friend, Trey Bobbinger, has already stolen my thunder on that. He always brings up that, so great. I told you, everybody's done my report. I do want to let you all know the Board of Nursing will be closed for the Christmas holidays, December 24th and the 25th. And I bring that up because we are in the RN renewal year. And the information, Shane, you can move to the next one. The information that I received from Dr. Cagle on yesterday, we have approximately 55,000 RNs, okay? 25,000, approximately 26,000 have renewed as of yesterday. So December 31st is coming quickly, and we will be closed for 2 days. So if you all know of facilities or nurses, make sure that the word gets out that they need to renew. We do send out throughout the Outspan Technology System reminders. So, but we do know that they wait to the last minute, and probably we'll see a surge of renewals in the next couple of weeks. But Operation Nightingale is ongoing, nothing new to report. That's always good. A good sign in that Mississippi does not have anybody on the Nightingale report. There are school programs that are continuing to pop up. I have not received any new information from the FBI on these new programs because it's an ongoing investigation. So they can't release that information until they take action on it. But Mississippi is looking good right now with none of these fraudulent graduates from these programs. Next, Shane. I believe that's all of my report. I told you it's gonna be short and sweet. Jeff, you have the packet before you with the information in it, and that information about the investigations. I did go back to the regulatory updates. OLRC, we did approve the appeals process, and I think Brandon he's in the room, and I think Madam President may bring that out of executive committee, but the OLRC, the appeals thing that went 2825, Brandon Hart. There it is. Appeal the board hearing panel to full membership of the board. We were called in on Monday and they did approve it. So then it has to go through that process of waiting for the amount of days before it can be final, but it was approved on that day. And That's all I have, I think, on that.
Yes.
Oh, if you didn't know, Brandon has been promoted to our general counsel. That's all right. So yeah, and he's done a phenomenal job since stepping in, and I think his promotion became final a couple of weeks ago, right before Thanksgiving. So we were excited, and we'll be looking to get him some additional help here sometime in the future. So thank you, Brandon. Thank you. That's it, Madam President.
Thank you, Dr. Johnson, and congratulations.
I have a question.
Yes.
On this gratuitous nursing issue, can you talk about it just quickly, some context and the significance of this?
I'm gonna let legal to legal talk to you, attorney to attorney talk. to you. And the gratuitous nursing, Mr. Castillo, was a definition that needed to be fine tuned a little bit based on some a matter that came before the board.
I can't, but it's on the agenda for, like, so you, is it okay if I go ahead and address that now? Is that?
Go ahead.
Okay.
Or is it on the acceptable?
Admin code committee, I can talk, I mean, I'm sure I'm gonna have to address it now or then anyway. It's just, a matter came up before. Gratuitous nursing is an exception, one of the exceptions in the code, with the code. It says essentially, if you're performing gratuitous nursing, you're accepted from the act, so you're not responsible by anything in the Nurse Practice Act. Gratuitous nursing isn't defined anywhere in anything. We did a lot of looking into other states and statutes and rules, and it's pretty much the same copy and paste the Nurse Practice Act. So this is an attempt to define it to avoid future problems and remedy past issues, so to speak.
So this is gonna be dealt with separately in another motion. Thank you.
Thank you. And next for board business, we're gonna move to request for approval of the business meeting minutes for October 4th, 2024. Does anyone want to make a motion?
I'd like to motion we approve the minutes.
Second, any discussion? All those in favor say aye. Any
Aye.
opposed?
TJ.
We had the other day, I think I scared everybody. Next on the agenda is request for approval of agreed settlement proposal minutes from October 2024. Do I have a motion? I'll make a motion. Second, all those in favor? Any opposed? All right, we'll move forward. Next, for future meeting dates, we have a request for approval of the 2025 board hearings and board meeting date. Before we move forward with that, though, we do need to make an adjustment in that schedule. On that one, we had discussion because according to Mr. Walker, we don't have a lot of ASPs for January. So we had the discussion of potentially canceling the January 14th date. However, what we will need to do is add in a day in April. And the date selected was April 7th, since we're already gonna have a panel here for hearings, just to add that additional day there. Any questions?
Madam President, also the March date, we talked about, for ASPs,
Yes,
both the January, March date.
it's not listed.
Oh, okay.
It's not listed on the sheet, so I didn't address it since it wasn't there.
Motion we approve the board hearing panel.
I only have one hearing date in December. That's the only time I'm listed.
Okay. Well, let's look.
That's fine.
Yeah, we'll look at it. So with that being said, the approval of the calendar for the year, I have a motion on the floor. Do I have a second? Second. Any discussion? All those in favor say aye. Aye. Any opposition? We'll move forward. Next, the administrative hearings and settlements will be February 4th, 5th, 6th of 2025 at 8:30 a.m. The business meeting will be on February 7th, 2025 at 11:05 a.m. The hearing panel will consist of Sandra Culpepper, Jeremy Cummins, Janie Clanton, and Mary Stewart. All right. Now we're gonna move to committee reports. So with that being said, we're gonna go to the executive committee first. So the first thing I need to request is a request for approval of ratification of the administrative denial. Case number 2022-1060. Do I have a motion?
I'll make the motion.
Second. Any discussion? All those in favor say aye. Any opposed? All right, other executive business, we currently do not have anything other than what is gonna be brought forth out of the administrative code. Brandon, you, if you'd like, you can address it there. Would that be okay with you, Mr. Walker?
Yeah, that's fine.
Okay. So next, we're gonna move forward to the compliance committee. Ms. Johnson.
I have three things. First, I need to, the board to adopt the recommendation that we accept one of the compliance affidavits two, and we accept two compliant affidavits one. So we just need to say yes.
Okay, so Nancy has a motion on the floor to accept the recommendations. Do I have a second?
I'll second.
Any discussion? All those in favor say aye. Any opposed? And we will move forward.
No, I have one more.
Oh, sorry, Nancy.
One, the next one is we need to accept the recommendation to add an addendum to R 880508 to extend their probation. If they're not in compliance, then their license will automatically be revoked. That's one. So I need a,
I make a motion, we extend probation on the said license.
I'll second.
and the last one is, we need to accept the modification to the final board order for P 327242 to take the requirements that she petitioned to the board for the removal of stipulations from the order, because she's already done it. So we just need to.
So based on Nancy's second motion that, Ms. Gentry and them, put the motion out there for, I need to get, a vote on it. All those in favor say aye. Any opposed? All right, next, that second part,
That's it.
Nancy had the motion on it. We have a second. All those in favor say aye. Any opposed? Anything further from your committee? Thank you. Next, we have the Advanced Practice Committee, Dr. Stewart.
We have nothing to report.
Y'all do a great.
We're very busy.
Thank you, Dr. Stewart. The next one is for the Practice Committee, Ms. Moody.
So we have nothing to report. I will mention that we are currently working on going through the position statements to make sure that they're all updated and current. And so that's where we are right now.
All right, thank you, Ms. Moody, for that update. Next, I am going to ask Ms. Gentry to go over the Administrative Code Committee.
Okay, we have one item to come out of the Administrative Code Committee, and that is the definition of gratuitous nursing. So, currently, the approved definition for gratuitous nursing is uncompensated care rendered by unlicensed friends and members of the family. This will be added as a definition in 30 Administrative Code Part 2870 under Rule 1.1. And it will be labeled as U under Rule 1.1. So I move that the board adopt, I make a motion that the board adopt the Administrative Code Committee's amendments to Title 30 of the Administrative Code Part 2870 to add the definition of gratuitous nursing to Rule 1.1.
Second. Any discussion?
Lacey, is family defined anywhere?
It's not, that's the wording that's used in, the statute under the exception. We pulled that from that excerpt. It says gratuitous nursing by friends and members of the family. That's what the statute says.
Maybe just some food for thought for the committee for next time. Maybe look at defining family, because, you know, in other parts of the code, it can be defined like to within the third degree of relation. Because you can get into a lot of weird definitions of what constitutes family. So y'all might want to just put that on your agenda for next time.
Okay, I appreciate that. Thank you.
So With that being said, I have a motion, a second. All those in favor say aye. Any opposed? Then we'll move forward. Ms. Gentry, do you have anything else?
I don't believe so.
Dr. Johnson covered it with the OLRC. I can speak to that if you have any questions about the appeals. So that y'all are all aware, appeals process, we have one today. But the way the appeals process is currently, that a licensee has 30 days to appeal after that board order. Then that starts a clock for essentially a briefing schedule. So they have 60 days to submit their brief. We have 60 days to present our brief after that 60 days. Then it's a matter of getting them on for an appeal for this oral argument y'all have today. The changes that y'all approved, we took to OLRC, eliminates all that. There was some concern from some of the members of OLRC as far as if we were just, in other words, getting the licensee out of here quickly because they didn't have a chance. And we were simply just saying, no, this is, those appeals are limited to the record, as y'all know. It's literally the record, what's at the hearing, the transcript, exhibits, complaint, and your final order. That's it. There's nothing there. So we were just saying that from now on, you would probably, not now on, once it's final. That won't be final for, I think we have to get that resolution back, and then it's 30 days from the date we get that resolution. But then at that point, it would be final, but you would have the record in front of you, and if that licensee wants to get on the agenda, the date their appeal is scheduled to be on the agenda, and y'all can set a time limit, they can address it, that's fine. It's an open meeting. But they would still have their due process right in an appeal as allowed by statute. But there will no longer be oral arguments or briefing. And it's just to get that, a quick appeal, a really quick appeal is 6 to 7 months, the way the process is now. And if somebody's suspended, like we had somebody get suspended this week, they're suspended that entire time. While that's great for the public, if they're appealing, it's not so great for that licensee if the process takes that long. So it's a good thing, I think, but that was the discussion at the OLRC. And they did approve it. Sorry, I left that out. They did approve our change. So.
Thank you, Mr. Walker. Any questions for him? All right, awesome. Let's move forward. Next, we're going to go to the Finance Committee. Mr. Cummins.
All right, you have your reports before you, and I'll try and make this brief. We're over our time. For our fiscal year 24 revenue, collected through October was $2,011,670. And this shows about a 2.45 increase from last year's period. So that's good. Under fiscal year 25 expenditures, the agency was able to award salary increases for the staff effective October 1st of 3%. We're actively recruiting for our vacant positions, have received authority from the Legislative Budget Office to recruit those above starting salaries. So you'll see that in your report there. And the second bullet point, travel expenses were much lower this month than they've been in the previous year. The agency has entered all of our purchase orders to encumber routine services. These services account for about 32% of the amount reflected in the total expense for services. Commodity expenses are much lower this year. That's great. The next bullet point shows ONW grants totaling $860,000 were released to the numerous nursing programs throughout the state in the month of September. And based on the grant awards and the other operating costs of ONW, the expenses comprise 50.85% of all the agency's expenses. So we put a lot of money into our ONW grants. The board share of the health insurance premiums are going to increase again this year. Agency's share of this increase will be 5% or $23 per employee per month. But the increase is within our budgeted salary allowances. Legislature is anticipating holding the budget hearings in early January for fiscal year 26 budget request. Our original budget submission included level funding in all categories except for salaries and grants. We are pressing to do another 3% increase for all of our employees, 5% increase for our nursing pens. And so the request also included adding $500,000 in addition to our ONW budget, which with the tool we were presented this morning, I feel will hopefully be very much successful. October 31st, our available, cash on hand was $6,460,315.47. Which is adequate for the full functioning of the board. And, we are in an RN renewal period, so we will have an influx. However, we got less than 50% of renewals that have come in thus far. So we still, I think, report was around 26,000 that come in, so we got quite a ways to go to get all our RNs renewed. So it'll be a busy December, for our board. That's a full report. Now, remember, I remind each of you each time I can, our RM renewals will put our cash high. The LPN renewals are not near as high, so this has to be 2 years worth of cash to sustain the board. So if you see the numbers going up, don't get scared of a sweep. I think everybody knows that we have to take care of our monies. All right, that's all of my report. Very simple.
So is there a motion on the floor to accept the financial report?
I have a question, this kind of general. So are all of our RN renewals come, the same time? They're not staggered?
LPN comes in, LPNs renew every 2 years, RN, so they're opposing years.
But
We've
each-
got triple the RNs than we do,
Right.
about 3 times RNs. So our influx of money comes in with RN renewals. Next year, when LPNs renew, you'll get a little bit, but not
Right.
near.
But the RNs are all come in 1 year. They aren't
Right.
split up.
Yeah, they'll come in from September to December 31st is when we see,
Right.
that movement happen.
Okay.
And RNs come in on even years because RN is 2 letters. And LPN come in on the odd years because LPN is 3 letters.
And
There you go.
There you go.
The science behind it.
There you
Never
go.
heard such.
That's
But
it.
that's great.
That is.
That's good. That's good.
So with that being said, do I have a motion to accept that finance report?
Motion.
Okay, Ms. Johnson made the motion. Do I have a second?
I'll second.
All those in favor say aye. Any opposed? All right, next we have the Office of Nursing Workforce Committee. Anything from you, Ms. Gentry?
No, we don't. I am grateful for the newly appointed chairship, so thank you, Madam President, and I look very forward to working with the new ladies. So excited. Dr. Burks and I have been in talks this week. We hope to meet soon and get the ball rolling, and excited about working alongside y'all. So thank you very much.
Thank you, Ms. Gentry. And next, we're gonna move over to the Legislative Committee with Ms. Clanton.
We don't have anything to bring out. I do want to thank Trey for answering my phone calls, like, what's this? What's this? And that we will be getting together real soon and probably just have a Teams meeting to kind of prepare for, nothing really much going to happen until January. Just kinda watch. Big flies on the wall.
Thank you, Ms. Clanton. So with that being said, is there any other business that we need to address?
I have something I'd like to say, Dr. Burks Johnson, thank you. Ooh, it's been a long week. Always models the behavior she expects from board members. So I'm gonna give the kudos to Brandon Walker, the compliance officers, the investigators, and the AG Kim and Alexis. It was a really good hearing week, and Brandon, you win it alone, so mouse claps to you and the staff, because it's a smooth week, and I am grateful. One of the smoother weeks I've had. So
Thank you.
I thank you, yes, Dr. Burks, and it's a result of your leadership, and we are. Dr. I got to go home and get in bed, y'all. Anyway, Dr. Johnson, yes, thank you, and Dr. Burks too, she's one of the favorites. So thank you.
Thank you, Ms. Gentry. And to reiterate what she said, Phyllis, Dr. Johnson, you said you're very thankful for us, but I think I can speak easily on behalf of all the board members, how grateful we are for you and your staff and how easy you make it for us to be able to do our job. I can't thank y'all enough for being that support for all of us to be able to do what we do. So with that being said, is there a second? All those in favor? All right, before everybody leaves, We're unmuted, correct? So
Yes.
we're all muted.
All right, everybody ready? Thank you. Good afternoon. We are here today in the matter of the licensure of Latasha, how do you say her first name? Latasha Clark, license number P327486, case number 2022-480. I'll let the record reflect, this hearing is beginning today at December 5th, 2024 at about 1:20 PM at, December 6th, at the Office of Board of Nursing located at 713 South Carroll Road here in Ridgeland. This matter is coming before the full board today pursuant to section 73-15-31-9 and part 2825 rule 1.1 as an appeal from a final order which was entered on May 14th, 2024, which revoked the license of Ms. Latasha Clark, who is the appellant in this action, after a finding by the hearing panel that Ms. Clark violated section 73-15-29, 1 C, E, G, and L. My name is Kim Turner. I'm an assistant attorney general, and I'll be serving as counsel to the board today. And I'll actually serve as the administrative hearing officer so that I will ensure that the process is orderly, to rule upon any objections, hoping there will be none, and to ensure that the hearing is conducted in accordance with applicable law and the rules. You guys, as the full board, you should have each, or as part of what's been provided to you, you should have received a transcript of the original hearing that was held back on February 8th, 2024, before the hearing panel at that time. And you should also have briefs that were submitted by the appellant and by the appellee, the board, with all the exhibits attached thereto. As a preliminary matter, I'd like to remind council that an appeal is limited to the record of the initial hearing. As no witnesses were presented at the February 2024 hearing, the entire record is composed of only those exhibits that were entered into the record at that time by the board, specifically marked therein as B1 through B45. Thus, neither party may seek now to include or refer to any new evidence or new testimony outside of that original record. Will the members of the, would you guys please all introduce yourself for me? And I'm going to start on the left.
Andrew Calhoun.
Alvino Castillo.
Janelle Moody,
Jeremy Cummins.
Sandra Culpepper.
Lacey Gentry, Hartley Walker.
Nancy Norris Johnson.
And I believe we have someone on participating by Zoom.
Yes, TJ Adams, RN.
Very good. I believe that with the introduction of board members, we do have a quorum. Statute requires that we have 7 board members, 3 RNs, and 2 LPNs. So the quorum is satisfied. If I could ask, would you please introduce yourselves for the record? Brandon, we'll start with you.
Brandon Walker, attorney for the board.
Mercier,
Doug Sear, I'm the attorney for Latasha Clark, the appellate.
the ground rules, I'm sure you both know, but just to recite them for the board, the appellant and the appellee, Mr. Mercier, Brandon, each will be afforded 20 minutes within which to present their arguments to you as the full board as to why the decision of the original hearing panel should be overturned or should be affirmed. Mr. Mercier, you may reserve a portion of your 20 minutes for rebuttal.
They can also modify.
I was getting to that, but thank you. You may reserve a portion of your time for rebuttal, meaning that Mr. Mercier may take 15 minutes and 5 at the end, but since we're here, would you like to reserve any time for rebuttal?
Yes, I think I would like to go 12 and 8 if I could.
Okay. And since the appeal was filed by the appellant will start the argument and conclude the argument with his rebuttal. Neither party is obligated to use his or her allotted time. Doesn't mean anything if they don't choose to use all 20 minutes. And the board can terminate the argument of either party if the board decides that it's heard enough and it no longer needs further argument on an issue. As we all can see, we have our court reporter here who's taken a transcript of this proceeding. So again, I don't think we need to be concerned, but make sure you complete your questions, complete your answers, don't talk over each other, articulate your responses, no shake of the head, no nod of the head, because our court reporter needs to take a transcript of everything that's said during this hearing, okay? Following the oral argument or following the argument of our attorneys, the board will deliberate as it does with our hearing panel. It will enter into an executive session and make a decision, and it will return from the executive session and announce its decision. The members of the original hearing panel, which I think we've already taken care of, the original members of that hearing panel must recuse themselves from all participation, and we note that those hearing panel members are not here. A written decision will be made after the final decision is announced at the open record, which I will prepare at the instruction of the board. It must be prepared within 45 days of today's date. All final orders issued by the board will be reflected by the board's minutes, and all disciplinary hearing proceedings are a matter of public record. So with that said, would the appellant is the appellant ready to begin?
The appellate's prepared.
Okay, appellee,
Yes, Your Honor.
you may proceed.
Thank you. Good afternoon. It wasn't my idea to do this on a Friday afternoon, so I know y'all don't want to listen to lawyers, but we're here. I'm representing Latasha Clark on an appeal from a final order of a hearing panel. Latasha Clark was not represented by counsel at that time. I was retained subsequently. A part of the basis for the appeal was the reason she was not present. Now, I understand the publication issues, and we'll get into that in a minute, but just to give you a broad overview, there's 4 basic reasons that we appealed this. The first one is because of the notice, what we call due process. There's a disagreement under the law about that. The second one is because the revocation was arbitrary and capricious. And the third one was because, I'll find it in a second. The evidence was not substantial evidence according to the law. Those are legal issues, and I'll dive into those a little bit. To give you the background here, Latasha Clark was working for an agency, and she was placed at the DeKalb Nursing Center. There was an incident that occurred with one of the residents there. She had had a fall on June the 2nd, I believe it was. She had gone to the hospital. She'd underwent a surgical procedure, went back to the nursing home, and then she was discovered to have had an unwitnessed fall. According to the documents, Exhibit B10 is a statement from Marshall Gully, RN, the DON. And Marshall Gully had a conversation with Latasha Clark and was recollecting that conversation. And Marshall Gully says about his conversation on the phone, and I stated, quote, "Yes, it was about supper time because the 2 CNAs were eating when housekeeping lady says she saw her on the floor and called for help." So a housekeeping lady at the facility discovered this patient on the floor and called for help. Subsequently, people came to her aid, including Latasha Clark, including her supervisor. I'll get to her name in a minute, excuse me. And 2 or 3 others, and they helped the patient get into the bed after she was assessed. Miss Clark did not document the fall. She did not report it to her supervisor because her supervisor was right there. Subsequently, she did make changes in the records after this conversation with Marshall Gully to place in there what happened. Now, her supervisor was there at the time, and she was an RN. Her name was Wanda Scarborough. I got the name now. Wanda Scarborough was her supervising nurse, an RN at the facility. According to the functions of the registered nurse and the functions of the LPN that are part of the regulations that this board has, the registered nurse is required to provide supervision on the facility. And it says that the RN, this is Rule 1.4 out of Part 2820, Chapter 1, The RN shall be responsible and accountable for communicating patient response to nursing interventions to other members of the health team. It also says in Part 2820, Chapter 2, on functions of the licensed practical nurse, Rule 2.1, the LPN gives nursing care which does not require the specialized skill, judgment, and knowledge required of a RN under the direction of the RN. And last, under 2.3E, it says that the LPN will provide care by performing nursing procedures and activities for which the LPN has the necessary degree of knowledge, skill, and judgment. According to the statements of both LaTosha Clark and Wanda Scarborough, there was interaction between them. Exhibit B6, which is on page 15, is LaTosha Clark's statement that she placed into the record. It says another employee said that the patient was on the floor. I asked patient what happened, and she said, quote, "I tried to walk and fell, quote, my hip is broke." Assessed her on the floor and manually picked her up with 3 others, Wanda Scarborough, which is her supervising RN, helping, to the bed. Did not complain of pain. She says, did not document. Did not call anyone. I asked Wanda, that's her supervising RN, about incident report. She said, it was too long, don't worry about it. Now, Wanda also told her, this is on page 16, Miss Wanda came around the bed and said with hand motion mouth to zip it. I would not say anything. You assess her, there are no bruises. Factually, this is an LPN following the directions of her boss, her supervisor, the person with greater education, greater authority. She didn't report it because she was told not to do it. Factually, that's what happened. Now, according to Wanda Scarborough, another witness, Tiffany Lewis, on page 34, says that Wanda checked her also and asked her, was she hurt? She said no. So that's what we know about the facts. Now, Wanda goes on and says on page 37, employee hollered that patient was on floor. I was at nurse's station. I went in room, LaTosha in room with 4 others, and went in to see if they needed help. I helped to manually lift her up off floor and onto the bed. LC assessed her on the floor. L. Clark asked me near 6 a.m. if she need to send her out and call the doctor. I don't, my reply, but I did not tell her to send her out. Ms. Scarborough also says that she tried to get her to take Tylenol, and she goes on and says she needed to go to ER. I thought LC was an RN and she should know what to do. And on page 39, this is probably the most telling part factually. Ms. Scarborough says, I tried to give her a Tylenol. Resident stated, no, that's poison. We were called to room saying that resident was in floor. That wasn't witnessed. And last, she says, if I had known the agency nurse, that's Ms. Clark, wasn't an RN, I would have handled the situation myself and should have done that anyway. This is a situation where you've got a chain of command, you've got more or better trained, educated nurse following the directions that she was given. It's similar to being in the armed forces, the Army. If the captain gives the corporal directions, the corporal follows those directions, which is what we had here. Now, I'm not saying that excuses everything that happened, but it's certainly something that's in the record and should have been considered by the panel. Now, according to the record, service of process was attempted on Ms. Clark by certified mail. It was not accomplished. There's no evidence that the board attempted to serve her personally, but what the board staff did do was publish. The publication, however, did not advise Ms. Clark of any of the charges against her. And the board's brief makes some issue about, well, she should keep them apprised of her address. There's no evidence that wasn't her address, but if she's an agency nurse or she travels, she may be gone for a few weeks at a time. She may not be home to check her mail. That's not uncommon. So as far as giving notice, the notice she would have received had she been home would have been a copy of the complaint and the notice of the hearing. Instead, what happened, there was a publication and it was only notice of the hearing itself, not what the charges were, not even a statute, no subsection, nothing. The publication was run for 3 weeks as required to be done, but it didn't provide the required notice. And this is where there's a big difference between what the board's attorney and what I say. According to the United States Supreme Court, the Supreme Court of Mississippi, for due process purposes, the notice, this is a quote, the notice must be of such nature as reasonably to convey the required information, close quote. And that comes from a Supreme Court case from 1950 and also the Mississippi Board of Contractors versus Hobbs Construction 2020 case. That's what due process requires. The board will tell you all you got to do is say, hey, we're going to have a hearing. Come on. Not tell you what it is, not tell you how to prepare, not give you any information to prepare. That's not what the U.S. Supreme Court says. They say due process says, or must, the notice must be of such nature as reasonably to convey the required information. The required information is what you're being charged with. You have no way to prepare a defense if you don't know, if you just show up.
That's time. For the board?
Yes, thank you, Your Honor. I'm just going to briefly touch on a few things. I think Mr. Mercier kind of gave you a little bit of a background. She was charged with, the charges are here in the complaint or in the brief, but with willfully acting in a manner inconsistent with the health or safety of persons under her care, making incorrect or false entries or failing to make entries in a record, and practicing in a manner that fails to meet generally accepted standards, and then practicing beyond her scope. As he's already indicated, we tried to attempt service through certified mail as the statute requires. And when that didn't work and came back, we published her as required by statute. That's all in the record and also in the brief. And he's kind of already touched on this too, but the appeal is not a rehearing, and it's literally limited to 4 grounds. Was the decision supported by substantial evidence? Was the decision arbitrary and capricious? Was it beyond the power of the agency to make, or did it violate some statutory right of the appellant or constitutional right of the appellant? The first is this due process issue, and we're governed by the Nurse Practice Act. 73-1531 sets forth the statutory requirements that determine service and how we get due process and notice on licensees of the board. If you look at that, it's in page 3 of our brief. It's quoted there, and I'll just kind of briefly touch that. It says, the executive director or a designee of the board shall fix a time and place for a hearing and shall cause a copy of the specific allegations and charges that's kind of an important part. It says, shall cause a copy of the specific allegation and charges to be sent by certified mail or served by personal service or process. That's when it's talking about certified mail. If you go on down, the legislature specifically sets forth how publication is done by service. It says when personal service or service or process by certified mail cannot be effected, the executive director shall cause to be published once in each of the 3 successive weeks, a notice of the hearing. A notice. There's nothing in there about charges, which is totally different than the requirement set forth in statute by certified mail. Additionally, it's the licensee's responsibility to update their address. You know, I wish we could get service through email. That would be great. But unfortunately, the legislature didn't give us that ability. So we have 2 options essentially. And if we don't have their address, or if we have the address they have on file, that's where we send it. So that's our service issue. We complied with the statutes. We did what we were supposed to do by the statute. There is no due process here. It specifically requires that notice of the hearing be served via certified mail or personal service, and it only requires notice of the hearing for publication. Going on a little further, the substantial evidence, there was unrefuted evidence admitted into the record. Excuse me, nothing was refuted at her hearing. As he's already stated, it's been established she did not appear. The evidence admitted included statements where Mr. Mashia has already pointed out where she admitted she didn't document or call one following the resident's fall. That's all in her statement. She also admitted there was no order. There's also no order allowed or no order provided for the appellant to administer the ibuprofen she administered. The decision was supported by substantial evidence. There's sufficient evidence that supports that. Going on down, I believe in the appellant's brief was talked about, and keep in mind, the burden that the board has to meet at the panel level is clear and convincing. You know, that's it. Everything that she admitted, if she admitted in her statement, which she did, it's in the record, that she did not document, that's exactly what she was charged with. That's clear and convincing. That burden's met. In the brief, there's talk about criminal, civil, quasi-criminal, all this. There's cases cited in the appellant's brief that talks about these quasi-criminal and the standard that has to be met. This is an administrative hearing, administrative court. The cases cited don't discuss quasi-criminal proceedings. There's actually a 2022 case that says proceedings that any administrative proceeding criminal, and if the Sixth Amendment does not apply to administrative hearings. So it kind of takes that even out of the context. There's also a talk about the bailiff and how her name wasn't called. If you look at the transcript and if you read the record at all, the hearing didn't go forward, I believe, until almost 7:30 that night. The notice was for 8:30 that morning. Her hearing got pushed and pushed and pushed. And when her name was called, she didn't speak up. Clearly she wasn't here, which has already been admitted. She failed to appear for a properly noticed hearing. It went forward with unrefuted evidence. So there's no question that she was guilty of the charges that were charged. There's also no question that this was supported by substantial evidence. And the decision of the board panel was not arbitrary and capricious. She admitted she was guilty of the charge. The board panel determines that they want to vote. That's what the board panel can do. That's within their statutory authority to do. The Nurse Practice Act gives you authority to revoke a license if that's the decision you want to make. It is not uncommon for someone who doesn't show up to a board hearing that they've been properly noticed for get their license revoked. It's not arbitrary. It's not capricious. Thank you, Your Honor.
Thank you. Mr. Mercier, your 8 minutes.
If somebody doesn't show up for a hearing and the panel says, okay, you didn't show up, you're revoked, without getting into the merits of the case, without viewing the circumstances, that is per se arbitrary. If you do not look at the merits, you say you didn't show up, so we're revoking you, that's arbitrary. There's no other way to cut it. As far as due process and what's required, we disagree. These are the regulations and statutes you're talking about. I know them very well. This right here is a copy of the Constitution. I carry it with me, signing on the back. The Fifth Amendment, it says, and I'll paraphrase, no person shall be deprived of life, liberty, or property without due process of law. A license, your license is property, and it can't be taken from you without due process of law. The U.S. Supreme Court has said what that requires. Notice must be of nature as reasonably to convey the required information. That wasn't given. I'll get off of that. Everything that was provided was hearsay. This board's allowed to hear hearsay evidence, to consider it. It is. But hearsay is dangerous. Double hearsay, triple hearsay, quadruple hearsay gets even more dangerous. But that's all that there was at this hearing. There wasn't even a sponsor of any of the exhibits that contained the hearsay. It was simply the attorney saying, here, we submit it. No witness sponsored that. That's all there was. You'll bear with me just one moment. These are the exhibits right here that were submitted in evidence. That's those. From the moment this hearing convened to the time the panel went to executive session, came back out and announced it, 29 minutes for the whole thing, to consider it and read all of this hearsay evidence and consider it. And they came out and they revoked. That's considered arbitrary and capricious. When you know you're going to revoke, you don't consider the evidence, you just come out and say, you didn't show up, we revoke you. They didn't say you didn't show, but that's the upshot of it. On substantial evidence, according to Mississippi law, hearsay evidence is not considered substantial evidence. I'll read from my brief. Because of the lack of reliability and trustworthiness, hearsay statements should not be considered substantial evidence, even if allowed into evidence at an administrative hearing in the state of Mississippi. And that comes from McClinton versus Mississippi Department of Employment Security. That's a 2006 Mississippi case. Also, it quoted from another case, a 1991 Mississippi case. So even if hearsay is properly admitted, in this case, there was no sponsor to it, it shouldn't be considered substantial evidence. That's all there was, 100%. So there was not substantial evidence. It was arbitrary and capricious to convene in the executive committee. I don't know how long, but the whole thing's 29 minutes. And you've got a nurse's license at issue, her livelihood. She's revoked. The board revoked her. She can't work. It's important. And should she have discipline? That's up to the board. But an automatic revocation for not showing up, that's arbitrary. And I just asked this board to consider this case and actually look at it and see if you believe that a revocation is proper or something less than a revocation. Give Ms. Clark the due consideration that it required, even though she wasn't here to testify. Thank you.
Thank you. So at this time, I will ask, the board will go to deliberate, and I would ask if we could have a motion to close the session.
Make a motion. closed.
You could ask questions. Do you just have questions for Mr. Mercier?
I do.
Oh,
I
okay.
have a question.
Yeah, but okay. Go ahead.
And if I'm out of order, I need, help me understand, Mr. Mercier, how, if you're referring to hearsay evidence, it's her own admission. So how is that hearsay if it's her own admission that she didn't document the fall?
Well, it's outside of the hearing, so it's still hearsay. And nobody sponsored it, said, oh, we got this, Ms. Clark. It's still a hearsay statement because it's outside of court, outside of the hearing. If she
If
says
it
it,
was her
if she says it,
own admission
if she says it here, it's,
documented, it's still considered hearsay?
That's to Mr. Mercier.
I'm sorry, okay, even if it's her own admission,
admissions are not considered hearsay.
right, but it was her own admission that she said I did not document, so that's considered hearsay as well? I'm confused.
Under the Mississippi rules of evidence, it would be taken outside of the hearsay rule. But you have to prove that she actually said it. There's no proof that she said it.
It was her
What-
documentation, correct? Excuse me, I'm
How
sorry.
do we know that?
I'm assuming it was her nurse's note.
How do we know that?
I
That's what I'm saying. Nobody said this is her nursing note. You have a lawyer who says, I got these documents here. There's no sponsor for it.
I didn't realize that hearsay, even if it's your own admission of guilt, is still considered hearsay. That's interesting to me. Thank you. Thank you.
I have a couple of questions.
Yes.
Excuse me. Why did your client not sign for the certified letter?
To my knowledge, she never received it. She was gone. She was an agency nurse and she works around different places. So to my knowledge, she didn't refuse to sign it. She just never got it.
Yeah. We're gonna be careful about questions. Remember, you're
I
limited to only the,
understand that, that's important. to
but
me.
that's outside of the record. So no matter what he answered, you can't consider that. You can only consider that was introduced in February.
The other question I have is, you're saying that the decision was arbitrary and capricious, panel decision. One reason you say appears to be strictly based on the time that the panel deliberated, is that correct?
That's one of them. Yes, sir. Pardon?
I'll just say that's one of the reasons, irrespective of what went into those deliberations, or you don't know all the discussions that took place even in that short period of time, but you're just saying based on the raw time that you consider that's per se arbitrary and capricious?
Correct. Based upon how long it took me to review these exhibits, based upon I'll leave it at that.
And the other, you also cited another reason I thought why you said it was arbitrary and capricious, was that, I was trying to take notes, was it because there was actually because the witness, your client was not present and the panel made its consideration without her being present? Did you say that was the reason?
No, sir.
What was the other reason? You said it was per se arbitrary and capricious, your first reason you gave.
If you are going to revoke a license simply because the person did not, the nurse did not appear for the hearing, that's arbitrary.
Okay, so because the person did not appear.
And you don't consider the circumstances and merits.
Okay.
And what I'm saying is, there was no testimony. Nobody read these exhibits into the record so that the panel could hear it. The only time they would be exposed to it is back there in deliberation. That's the only chance they had to look at them, read them, digest it, discuss it. Because it was simply, the board's attorney said, we move these be introduced into evidence, and the hearing officer agreed, and off they went. And it was very late, and I understand, it was very late at night, but this is something that I think is important to this nurse and important to others as well.
But your client had an opportunity to be there, but wasn't there because of whatever reason. Because she didn't accept the letter.
Yeah, I can't answer that.
Any other questions? Okay, so now I would entertain, ask for a motion that we go into, the board go into a closed session to determine whether or not an executive session is necessary.
I'll make that motion.
I will second.
Thank you. All in favor?
Aye.
Any opposed? Any abstaining? I would ask if someone would please make a motion for the board to go into an executive session for the purposes of deliberating the arguments and exhibits and rendering a final decision in this appeal.
I will make that motion.
I will second.
All in favor?
Aye.
Any opposed? Any abstaining? Okay. Do y'all stay here?
Usually we stay in.
Let the record reflect that we are now back on the record at about 12, I'm sorry, 2:50. I need to go home too. At 2:15 PM. And the board, after having deliberated, taking into consideration the briefs of both parties and the exhibits that were introduced into the original record, as well as attached to both the brief of the appellant and the appellee, the board did by unanimous vote uphold the decision of the hearing panel from the February 2024 hearing, therefore finding that the respondents or appellants license herein was still revoked. So, and that will be, of course, like I said, we will boil it down to a final order within the next 45 days. And with that matter, we will stand adjourned from this hearing. Thank you.